So, Okansi, let me thank you so very much for having me this morning and to extend my felicitations to my senior former colleague at the in politics, a cabinet minister. Before I was cabinet minister, he was. And before I was a lawyer, he was. And so he's a senior lawyer at that. And the only profession that respects seniority is law. And so you can see there is too much at stake here for us to engage in barroom views or talks. If I agree entirely with Senior that the circumstances surrounding the invitation, restriction, detention, or arrest of Frimpong-Boateng is bizarre. I agree entirely, it's bizarre. We are confronted with an apocalyptic matter. The destruction in our mining sites are catastrophic. I mean, and so when Ken Ashigbe and the media coalition against illegal small-scale mining started the talk and fight against Galamsey, we supported it and supported it seriously. And so we were encouraged when His Excellency the President said he was putting his presidency on the line. We thought that showed some level of understanding of the devastation in the mining sites and that he was willing to do something about it. Subsequent events clearly point to the fact that that statement was grandstanding, had nothing in fighting illegal small-scale mining. The President had established the Interministerial Committee Against Illegal Mining and put Frimpong-Boateng at the head, as head. And so we need to look at the evidence provided by Frimpong-Boateng in his report. And we should be honest about it, that the fight against illegal small-scale mining is not yielding results. And it's not yielding results because of the personalities, characters, and persons involved in the illegal mining activities. Yes, so you asked a question, a legal question, and I think that reading the Constitution, and particularly Article 14 of the Constitution, there appear not to be anything wrong with the invitation of Frimpong-Boateng and his subsequent restriction and detention or arrest without a charge, because the Article 14.3 says that a person who is arrested, restricted, or detained, and I'm particularly interested in B, upon reasonable suspicion of having committed or is about to commit a criminal offense under the laws of Ghana, and who is not released, it continues, shall be brought before a court within 48 hours after the arrest, restriction, or detention. Then 4 says, where a person arrested, restricted, or detained under paragraph B, I'm ignoring the A, of clause 3 of this article, is not tried within a reasonable time, then without prejudice to any further proceedings that may be brought against him, he shall be released either unconditionally, so they could simply let Frimpong-Boateng go, or upon reasonable conditions, and that was the 2 million cedis bail, including in particular conditions reasonably necessary to ensure that he appears at a later date for trial or for proceedings preliminary to trial. And so what happened on that day, unfortunate as it is founded in law. The Constitution supports it. So he was called, invited to appear before a special prosecutor. The special prosecutor has reasonable grounds to believe that a crime had been committed and he's a subject matter of investigation. He spent close to 4 hours, I'm told, at the special prosecutor's office. And that is a detention of a sort. That's a restriction of a sort. Within that 4 hours, he could go nowhere.
Yes.
And the conditions for his release, for him to have his temporary freedom, was the bail of 2 million. Never mind that he was not charged, because my understanding is that preliminary investigations are still ongoing. And so he has not been charged with an offense.
I see, but the article that you read says that there should be an establishment of having committed a crime, right? It's in the...
Yes,
so yes, he asked what he had done, and he wasn't told exactly the crime he had committed. That's number one. And then that 48-hour window that you also mentioned in law. I mean, from 16th May till now, I asked him if he has had any other invitation. He says, no, nobody has contacted him between then and now to have a follow-up or some further questioning. So is it the case that this can happen and you actually don't know what you have done? Because he says he asked what is his crime, but they didn't tell him.
Well, I'm very interested in the investigations of Frimpong-Boateng, and I have said that if the investigations subsequently lead to his prosecution, I will be in court.
You will be in court?
I'll be in court. One, to understand, because Frimpong-Boateng's report, for want of better word, is a redacted report. He should have more evidence to put before the court. And one who is interested in protecting the environment will be interested in listening to Frimpong-Boateng. And let us get it straight. I have never said, and I don't believe, that Frimpong-Boateng is a saint or an angel. Like my senior said, there is a comprehensive legal regime in the Minerals and Mining Act that deals with matters, things, articles seized by security forces or persons charged with the responsibility of fighting illegal small-scale mining, and how to deal with those articles. The fact that gold nuggets were seized, and we had the small-scale miners say that. The fact that money was seized from the operations of the Galamstock. The fact that excavators were seized, and Frimpong-Boateng admits to that. How come that the comprehensive legal regime that is in our law was not followed? Why in dealing with the articles that were seized, or machines or vehicles that were seized, they failed, refused, or neglected to follow the prescriptions of the law? And so I think we need to understand what happened. In Ghana, there is no vicarious responsibility for the commission of a crime. And so people who were in charge, the office had a secretariat, and people were detailed to go onto the field to effect the policies and directives of the committee. And so those people should and must be held personally responsible for the way they dealt with and treated articles that were seized from the illegal small-scale mining sites. You cannot say that because Frimpong-Boateng was head, he should be vicariously responsible for all omissions or commissions on the mining, by officers of the Interministerial Committee. That said, you could by extension argue that if you are making Frimpong-Boateng directly responsible for acts of commission or omission by officers of the Interministerial Committee simply because he was head, then we could say by extension of argument that Nana Addo Akufo-Addo ought to be invited by the special prosecutor.
President Akufo-Addo ought to be invited by the special prosecutor?
Yes,
Why?
because the the mandate of Frimpong-Boateng springs from a delegated authority that was given him by the president, and the president has executive authority is vested in the president. Article 58 and Article 295 defines what executive authority is the power with which government acts. So when the combined effect of Article 58 and 295 is that government is the president and the president is government. And so the delegation of that authority in Article 58 to Frimpong-Boateng does not take responsibility away from the president. And so if the president appointed him and then there were acts of commission or omission, then the president must bear responsibility for appointing a person who, in quote, was not fit for purpose and who is not standing trial. If we want to extend the argument. But I still say that there's no vicarious responsibility for the commission of a crime. That is the reason why, for a very long time, Ghana has been fighting the Trokosi system, because we do not believe that children should be responsible for the sins of their fathers. And so Frimpong-Boateng should not be responsible for the sins of officers of the commission who violated the law in the implementation of the directives.
Okay.
But clearly, the evidence contained in Frimpong-Boateng's report speaks to matters that should agitate the minds of everybody. And again, the treatment, because no one should be subjected to discriminatory treatment. And I think that Frimpong-Boateng was subjected to discriminatory treatment by the Office of the Special Prosecutor. Because we have seen political appointees appear before investigative bodies and given self-recognizance bail. Self-recognizance bail. In this case, Frimpong-Boateng was treated as a common criminal and asked to post a 2 million cedi bail. He had to take his friend to post the bail for him to obtain his temporary release. And I think that is discriminatory in the fact that Frimpong-Boateng has served. I'm not saying that he served excellently, but I'm saying that he served.
Right. Well, Inusah Fuseini, hold on that thought for me. Let me bring Engineer Dr. Ken Ashigbe on this one as well.